Regulatory changes may be coming to the PERM prevailing wage rules in 2026. My name is Jie Huang and I am an immigration lawyer at Scott Legal PC in New York. Today I'm going to talk about a key change to look out for in 2026 that may be coming to the PERM program with respect to how prevailing wages are calculated. On December 17, 2025, the Department of Labor submitted a proposed rule for review at the Office of Management and Budget before it will be released to the public for notice and comment. Submitting a proposed rule to the OMB is the first step in the U.S. federal rulemaking process. We don't yet have access to the full contents of the proposed new rule, but the rule refers to wages in the PERM labor certification process. The PERM process is what U.S. employers go through to show that they can't find qualified candidates among U.S. workers, which allows them to apply for a green card for a foreign national worker to fill that job. We'll get more clarity about the exact contents of the proposed new rule once it clears OMB review. As of now, we anticipate that the proposed changes may be related to changing the way that the prevailing wages are calculated in a way that significantly raises them. Lawyers are guessing that the proposed changes may mirror a previous rule published by the first Trump administration on January 14, 2021, which was challenged in the courts and later ended up not being implemented by the Biden administration that followed. First, let me explain what do we mean by prevailing wages. The prevailing wage refers to the average wage paid to similarly situated U.S. workers in the area of intended employment in the same occupation as the job being offered to the foreign national. To be able to petition a green card to the foreign national, the U.S. employer is required to pay a wage that is at or above the prevailing wage. Needless to say, to ensure fairness to U.S. employers who are trying to fill a shortage of qualified U.S. workers to meet their labor needs, and to stay true to Congress's intent in creating the labor certification program, it is critical that prevailing wage levels used by the Department of Labor accurately reflects what is the actual average wages of U.S. workers in that region, in that occupation. Then the important question is, how do we determine the prevailing wage? In most cases, we rely on data from the Bureau of Labor Statistics Occupational Employment and Wage Survey data, which collects U.S. workers' wage data. From this data, the U.S. Department of Labor uses a four-tiered system to estimate the average wage in a particular occupation based on the level of the position. For example, the salary of a junior engineer fresh out of school would naturally have a lower average than the salary of senior engineers with 10 years of experience who normally would handle much more complex duties. In recognition of this, the current system calculates the level 1 wages for a junior entry-level position in an occupation at the 17th percentile within the total distribution of wages, level 2 wages at the 34th percentile, level 3 wages at the 50th percentile, reflecting more experienced workers, and the highest level 4 wages at the 67th percentile, representing the wages earned by the most senior level workers in a profession. Previously, the first Trump administration published a rule in January 2021 that required DOL to use a different formula to calculate prevailing wages, which would have the effect of drastically increasing the wages a U.S. employer would be required to pay to a foreign national in order to sponsor them for a green card. Specifically, the January 2021 rule redefined level 1 wages at the 35th percentile, level 2 wages at the 53rd percentile, level 3 wages at the 72nd percentile, and level 4 wages at the 90th percentile. This essentially means a U.S. employer would need to pay a junior employee a mid-level salary in order to hire them permanently on a green card. For experienced positions at level 4, an employer would need to offer to pay them at the top 10% in the entire profession in order to sponsor them for a green card. I'll provide an example in numbers that illustrates just how much of an impact this could have. Assume a U.S. employer in Knoxville, Tennessee can't find a U.S. worker to fill a junior entry-level software developer job in that city. Under the current system, a U.S. employer in Knoxville, Tennessee would need to offer a yearly salary of $79,000 for a junior entry-level software developer for a level 1 position in 2025. Under the new rules, the employer would need to offer over $97,000 salary for that position. So what does this mean for employees and employers? If DOL ends up revising the prevailing wage rules to mirror the previous 2021 proposal or go even further, practically this would mean employers who are trying to fill permanent labor shortages by sponsoring green cards to foreign national employees would need to offer to pay foreign national employees significantly more than what is expected at their level. In many cases, the employer would need to offer foreign national employees tens of thousands of dollars more per year. For many small U.S. businesses that cannot afford to pay such a premium, the option to sponsor foreign national employees to fill permanent labor shortages may simply become out of reach. For prospective employees who may need a green card, they may likely find that many employers may be unwilling to sponsor a green card because they would need to pay significantly more than what is expected for the level of the position. In other words, if DOL ends up shifting the prevailing wages to such a degree as it proposed back in 2021, it would make it prohibitively expensive for many U.S. companies to use the employment-based green card option to fill permanent labor shortages. Given all of this, U.S. employers and prospective employees should keep a close eye on further movements on this proposed rule and seek the advice of counsel to proactively understand how these changes may impact you. Scott Legal PC is a full-service immigration law firm with a wealth of experience in the full range of immigrant and non-immigrant visa options, and we will be happy to assist you. Please do not hesitate to reach out to us.